Okay, it's part 7 of the trial, and they're continuing with the lead detective on a case.
Continue discussing your assignment on the night of August 25th, 2021. Excuse me, before we took a break. 2020, thank you. Before we took a
So you normally don't correct the DA, but if he gets a date wrong that you want to say it right so to make sure they can't say you don't even know the date. So that's why the cop had to correct him. The DA said 2021. It was supposed to be 2020. He heard the guy correct him. He wasn't trying to be a smartass. He just wanted to make sure, hey, we're talking about 2020, right?
break, you were talking about going on the internet and downloading some videos, and we're going to get back to that in a second. But I want to go back to the evening of early morning hours into the next day of August 25th, August 26th, 2020. Did there come a time in which you learned the identity of the person who had shot people that night?
Yes.
How did that come to be?
There was information on social media, and also we received information that the person had turned themselves in at the Antioch Police Department.
Prior to the defendant turning himself in at the Antioch Police Department, did you have information identifying him as the individual who shot and killed 2 people that night?
There were pictures circulating on social media.
Were you able to see or figure out the identity of the person in those pictures?
Early on in the investigation, I recall seeing a picture, but I don't recall knowing the identity of the person immediately.
Did there, after the defendant turned himself in to the Antioch Police Department, did you go down there in person?
Yes.
And did you have face-to-face contact with the defendant?
Yes.
Did the defendant indicate to you that he had suffered some injuries that night?
Yes.
Did you take photographs and document those injuries?
Yes.
Can you tell the jury about those injuries?
He had an approximately half-inch scratch above his left eyebrow. He had a small cut on the inside of his lower lip, slightly offset to the right. There was a approximately 2-inch scratch below his left collarbone. There was some redness to the right side of his belly button, just above his waistline. There was an approximate 2-inch scratch on his left forearm. There was some redness on his right forearm. There was some redness on the tip of his right thumb. And on his back, there was a scratch somewhere on his left side, about where the left shoulder blade would be, in that approximate area. And also, there were 2 bumps on the back of his head that was approximately here, so above the left ear. Both of those injuries on his head, I could not get to turn up in the photograph because Mr. Rittenhouse has very thick hair. But with the gloved hand, I was able to feel it. And both of these bumps I would approximate to be the size of a penny. And the skin was slightly raised, and I was able to feel that with my hands.
Okay, so he made these sound like scratches, etc. What the defense ought to come back, and they ought to be covering and writing this down right now. If I was there, I'd be writing down. He needs to be asked, isn't it standard protocol that during domestic violence, you may see little to no injuries, but 2 or 3 days later, because that's how long it takes for a bruise to come up, isn't it routine and normal investigative practice to go back and re-photograph injuries after a few days to see the swelling, the bruising, whether it got worse or better? Did you do that? My guess is they didn't do that. And he ought to make sure that the jury knows they didn't do it and that they're kind of poo-butting these injuries.
Was that the extent of the injuries that the defendant reported to you?
Yes.
Now, I know you talked about getting some videos off the internet. Was there a time in which you also collected some physical evidence from the scene of the shootings?
Yes, at 63rd Street and Sheridan Road, yes.
And can you tell us about that?
That was on August 29th. We had a citizen by the name of James Powarczyk. I might have gotten his last name a little bit off, but I think there were 2 W's in there. I think it was Powarczyk. We got a report from that the citizen came to check out the area of where this had happened, and he located 2 shell casings underneath a silver Chevy Cruze in the car source parking lot.
Karen, that last name is P-I-W-O-W-A-R-C-Z-Y-K. After receiving this report, did you go to that scene to check out these shell casings?
Yes.
Did you recover those shell casings?
Yes.
And what were they, specifically?
They were 2 Aguila 223 REM shell casings, and the location of where they were located, the silver Chevy Cruze was right in the area of what I had seen on the videos of where the shooting of Joseph Rosenbaum had taken place.
Thank you. Now, you mentioned earlier that as part of your investigation, you searched social media, the internet, etc., to gather videos of this particular night. Is that correct?
Yes.
Okay. I'd like to go through some of those videos now in your testimony. Let me turn the TVs on. Oh. This is a video which is on our list as exhibit number 18, and this is a video from a news source called The Rundown Live. So if we could begin this, begin playing this at the very start, please.
Now they're a news source when the government wants to use them. When they try to photograph police officers, they're just harassing the police. But now they're a news source because they can help the government. See how that works out?
Kristan T. here at the Rundown Live, and I'm here with a bunch of militia. They're protecting a local car shop across the street. I saw yesterday there's video of it on YouTube, of this one burn. And we had that fired, people are hitting it with bats and a whole bunch of other things.
I have an objection to this audio being played and the editorialization. I don't have a problem with the video being played.
I think we agree with the authenticity of it. I think that the individual who recorded this is available to be subpoenaed if necessary.
Well,
I don't think it's...
there's a rule of confrontation.
Maybe approach around. I don't want to see this.
Okay, I missed this. I'm not sure what... I think he's trying to say who recorded this, and if you're going to admit it, who's going to validate it and verify that it's authentic and it hasn't been changed. And I was thinking the same thing. Before he said that, I was like, I wonder if they interviewed this guy and said, did you take this video this night and talk to him? Because when he said militia, I want to know, did he just make up that name, or did he talk to the people and they say we're militia? Because that militia term is thrown around a lot like a racial slur to anybody with a gun or any patriot. But I want to hear what his objection is again, if I can.
The authenticity of it, I think that
And we had that fired, people are hitting it with bats and a whole bunch of other things.
I have an objection to this audio being played and the editorialization. I don't have a problem with the video being played.
we agree with the authenticity of it. I think that the individual who recorded this is available to be subpoenaed if necessary. I don't think it's...
Available to be subpoenaed. Why didn't you subpoena him? You subpoenaed the other guy who helped you, and you put him on the stand to get his video in, but this guy, you didn't subpoena him, and he's available, and you don't see a problem. Man, this dude's a weasel. This guy's kind of laughing like, really? Did you just say that, you freaking idiot?
There's a rule of confrontation.
Maybe approach around. I don't want to see this.
Well, start there. Start from that position and we'll see. It's a confrontation issue.
Maybe approach around. I'm sorry. It's
No, because it's be something that has to be a record, and I'll have to send the jury.
It's not. I don't believe it's a confrontation issue, Your Honor, because we're going to be here. We've already heard audio from other witnesses, and we're going to hear more.
There was not an objection.
See, he doesn't want to do this in front of the jury because it's going to open the door and the jury's going to say things. He keeps wanting to do it off the record or in chambers or approach, and the judges are like, no, deal with it. And he's pissed.
I can tell you, if there's descriptive material, then he's entitled to confront the speaker.
There's not descriptive material of the defendant, Your Honor. This is not a confrontation issue.
You've heard it before?
Yeah, I've seen it in its editorialization.
He's already made statements, assertions of fact.
He just made one.
He did.
Yeah, he just made the assertion that it was militia guarding.
Okay, we can play it without the audio. There will be times in which we will have audio of interactions with the defendant, where he makes statements.
Defendant's statements are admissible.
All right, I'll do my best to alert you when those occur.
I'll do my best. That means I'll let the jury hear it and then I'll go, sorry.
So let's play without sound for now.
When I studied evidence last century, the evidence textbook, which was probably about this thick, about a quarter of it was dealt with the hearsay rule. You hear the word hearsay all the time, and the section on the hearsay rule began, there is nothing murkier in the law of evidence than the hearsay rule.
It is freaking crazy, the hearsay rule. The hearsay, I think, is information or facts that's asserted for the truth of the matter. And then there's all kind of exceptions like dying declaration, like excited utterance, third party. Cops are allowed to repeat hearsay because they're in their official position, but normal people can't. Hearsay is just one of those things that is murky, muddy, and they always try to play the game of either keeping it out or admitting it through an exception.
and I can tell you from 50 years of experience that that is accurate. It is a rule that has many, many exclusions, and it has many, many exceptions. So some things that may seem to the untrained ear to be hearsay are not, and some things that don't seem like it are. Basically, the rule is that a statement of a non-testifying person cannot be offered to prove the truth of the matter which is asserted in the statement. The rule, this is something we actually referred to on the first day when I talked about what's introduced in evidence has to be under oath. It has to be subject to cross-examination. And that's not true of statements that are made by somebody who's not here while testifying as a witness. He's not here on the stand, he's not under oath, and he's not subject to cross-examination.
Which means you have to get it in through a hearsay. So if I'm dying and I say, Billy Bob shot me, that's acceptable in the hearsay rule because I was a dying and it falls under dying declaration exception.
So this person who's describing this is occurring on a discussion that you or I might have if it didn't require the strict rules that we have in the court. It's perfectly, ordinary conversation. But when it gets into court, and this is actually referred to in the Bible, St. Paul, when he was put on trial.
Holy shit, he's going to the Bible now? Are you kidding me, dude? If there's somebody on the jury that's anti-religion, they're not going to like him. And if the prosecution is anti-religion, he's going to be pissed. I can't believe he's starting to quote the Bible. What the hell? What happened to separation of church and state?
I think it's Caesarea. Well, it was over in Palestine, in Israel. He was accused of some activity, and he was a Roman citizen, which was not common, but he happened to have been a Roman citizen, and so he had rights that we share now as Americans. And when they tried to put him on trial with evidence which was being repeated by somebody who wasn't there and under oath, he said, "Where are the witnesses against me? I am a Roman, and I have a right to confront my accusers. They should be here." And so that led to actually his voyage to Rome to have his case heard before the emperor. So it's an ancient rule. It's strictly enforced in the criminal courts for very obvious reasons. So that's what we're talking about here. And
I think it's good that he's educating a jury on these objections and these arguments, because that's always a gray area, and the jury sometimes will infer a negative or a positive from the argument, and it really isn't what was really discussed at all. So I kind of like the fact that he's giving the jury a little education on why they're arguing over hearsay and why the defense has a right to be able to confront this guy. He's not being bad or mean or pulling tricks. So I kind of like that he's doing this.
So if the person who's making this descriptive material is here and can be put under oath and cross-examined, then it's admissible. But otherwise, it is not admissible through the officer here.
This is what's called a slick lawyer trick. The DA or the government will always try to sneak shit in, and maybe the defense attorney isn't paying attention, and they'll let it in. Even though they know they shouldn't. This DA knew he shouldn't do this, because he already proved he knew he shouldn't do it. He brought the other guy in to confirm his videotape, but this guy he was going to try to slide in.
You can play the video. And now, one of the exclusions from the operation of the rule, there was reference here to there were apparently statements, the state claims were made by the accused. There's an exclusion. That is not hearsay. A statement made by a party opponent is not hearsay. So he's entitled, the district attorney is entitled to have the sound up during those if they are statements of the defendant himself. So, go ahead.
We'll continue the video without sound. There will be a moment shortly where we'll turn the sound back on, but for now we'll just play without sound. Pause for a second there. Detective Howard, have you had an opportunity to watch the video we've been playing so far?
Yes.
Okay. May I set up that easel again, Your Honor?
Sure.
Thank you. You've seen the video thus far. Are you able to identify the location of where this video is being taken?
Yes, the videographer at this point in time is on the southwest corner of Sheridan Road and 59th Street. It looks like he's in the car source parking lot. I'd say about there. The viewpoint of the video is pointing north towards St. James Church.
And we've already heard some testimony about the fact that St. James Church on our map looks like it's got a structure there, but in the video it's changed. Are you familiar with that?
Yeah, St. James Church at this time, and a little bit prior to these incidents, was going through a demolition.
Okay. Thank you. Please.
Well, the former school building,
Yeah, the school building.
not the church.
Correct.
Let's continue the video, please. let's pause 1 second here, and can we turn the sound back on? I think everybody's in agreement. That is the defendant, correct? Okay. So let's turn the sound back on briefly for this section, please.
We're live on the Rundown Live. And as you can see, there. Do you have a good angle? Yeah, very cool.
We're only hearing the guy videotaping talking. The judge just ruled that we can hear Kyle's statements, but we can't. The video guy can't be talking.
And you guys local or no? Yeah. Okay. Cool. No, we'll do this.
Coronavirus?
Oh, dude, I'm not afraid of no coronavirus.
Yeah.
In fact, my shirt underneath it says I survived the coronavirus. There you go. Yeah, it's very possible. What was that? Oh, bro. Believe it or not, I've been doing this for about 12 years, so 41.
Why isn't the defense objecting? Your Honor, he's playing a videographer. He's not playing my client. See, the DA is, if you give him an inch, they'll take a mile. He's getting things in that the judge already said he can't, but the defense isn't objecting.
And, if you guys see me get hit with something, I'm knocked out, that's when I need help.
Yep.
Or if it looks like somebody's going to beat me at the club, then I need help. Other than that, I can...
We'll be there to help.
Non-aggression principle. I don't want anyone hurt.
Dude, object already. Your client isn't talking.
They have medics, too, and their medics are pretty helpful, even though they might be on the other side, if that makes sense. But they'll help me, okay?
We got medics too.
Okay, cool. So, do you guys mind?
We'll turn the sound off now to continue the video. Thank you.
He got away with it, so I guarantee he's going to do it again.
Misspoke. Let's go back a few seconds and turn the sound back on. Yeah, let's continue with the sound at this moment for a little bit, please. Thank you.
They have medics, too, and their medics are pretty helpful, even though they might be on the other side, if that makes sense. But they'll help me, okay?
We got medics too.
Okay, cool. So, do you guys mind? Is there a way up on the roof? Okay, no, that's fair. I thought I'd ask and make for some cool footage. But we got militia members.
Let's turn the sound off now, please. Thank you.
Notice they named this Kyle Rittenhouse, armed, hand out water, militia. So this is a subliminal message, and DAs will absolutely label things and put comments on pictures and videos so the jury gets to see it and it'll stick in their mind. I would have not allowed this. I would say rename it or blur this out.
Can we pause the video for a second there? No dispute on that. Okay. I'm going to use, may I use that sister, what's her name? Sorry. Marciana. I always say Marciana. I'm going to clarify for the jury. I'll do it on the screen here if I can. So that is Dominic Blackwood. Thank you. Pause there. Now, can we please skip forward to the third? All right, thank you. Can we play from there? No sound at this moment, please.
I'm not sure why we're watching this. Probably the jury's thinking the same thing. Am I supposed to be looking for something? What's your point?
Pause for a second there. I don't think there's any dispute on both.
You know what? The defense ought to say, Your Honor, can we just have the defense go back? Or can we have the prosecution go review the tape at the next break or do this tomorrow to where he knows when he's hitting play, it's my client. Otherwise, subpoena the guy who did this and have him come in. I mean, that's all he has to do. And the judge will be like, I agree. You keep playing information that isn't your client talking, and I've already said you can't do that. But unless the defense brings it up, it's not going to happen.
For the jury's purposes, I'm just going to point out this individual that is going to be walking towards the camera is Ryan Walsh. And then we just saw the defendant on a car that was leaning against a car that was off to the right of this. So he may come back into view again, but just wanted to point that out for the jury. Please. Can we stop 1 second, please? Can we go back to the point where the defendant comes into view and turn the sound on, please? Right there, please. Pause and let's turn the sound off, please.
All right.
Who's a fast runner?
Oh. Yeah, don't instigate. Don't just stand there. They're not going to cause any problems.
Turn the sound off.
So we got the militia here.
Stop.
Again with the militia.
Stop. Sorry. Turn the sound off, please. Thank you. All right, let's go to the 48-minute and 45-second mark, please. Turn the sound on for this, please.
We talked to them a little earlier, and they've been pretty nice to me. They've kind of let me come and go. How you guys doing?
Hey, where you with?
The Rundown Live. So,
Got a reporter in the perimeter.
all right, they're saying I'm in the perimeter. They're making awareness that I'm here. All right, they're asking me to leave.
Why is all this audio being allowed when it's not his client? This is a huge error on the defense.
And we got the militia here.
Where we go with the militia again. He's only said it 10 times after the judge said, unless the client is here, it's hearsay. And all this hearsay is being allowed in because the defense is freaking sleeping.
They're trying to protect private property. They're trying to protect their property. Everyone got that right. Yeah, no shit. I don't disagree. That's
Hey, they
different.
implemented us when we down there.
Oh, were they?
With the green laser.
Oh, I didn't know
Yeah.
that.
See, if you give the prosecution a chance, they will absolutely abuse it and use it. This is bullshit.
With the green laser.
That's bullshit.
Yeah.
No, that's not cool. But I think a lot of them just are scared. So they're just trying to protect their property.
I guarantee you, if an objection happens and goes against the defense, the prosecution will not allow it to slide like this.
Bro. I agree with this guy. These guys are trying to protect their property up there. Yeah, they're just trying to protect their property.
Oh, yeah, I know, but they...
Like if that was my house and I didn't know what was going on, Yeah. Well,
I just assumed they were like some old guy.
no, I think one of them they clicked the laser pointer and they're
What happened to this guy can't talk? Why am I the only one that's freaking bringing this shit up? And there's not 3 freaking attorneys sitting there allowing this shit.
probably somebody's trying to be a copy
They got
dick.
the right to do that.
Yeah, I know, but it's still being a copy dick, though, you know.
That's true.
Because those things are loaded. That's not for fun. That's not for fun. That's not painful.
Why is this guy being allowed to freaking talk? This man, this irritates the shit out of me. If I was in the court, I'd be looking over the attorney and go, are you going to object? Why is he playing the audio? And I'd have said it loud enough for the judge and the jury to hear me.
But they got, yeah. Back to my point, not all militia should have guns, because if they're pointing lasers at people from the roof, that's not cool either. So that's what caused it. So allegedly,
So now they got in that they were pointing lasers from the roof. We already had this discussion, and now this guy, the Rundown Live, gets to start telling us what happened after the judge has ruled that he couldn't. This is the bullshit that just sucks. And government does this all the time. And if you're ever charged with a gun crime, they're going to do it against you. You can guarantee it.
the reason why they were upset is somebody pointed a green laser at them, so they there's a loaded gun, so people will take it. De-escalation. Yeah, there's a de-escalation, you know.
It's the same as the earlier objection. If he wants to play my client, that's fine, but this is editorialing.
About freaking time. And look at him. He looks like he's shocked. Like, wow, I didn't know, Your Honor. It was an accident. That's bullshit.
I understand the objection. The problem is there are portions of this that don't have anything to do with the defendant that describe the scene, and I'm trying to give the jury a sense of the scene.
See, so he's going to say, look at me, Your Honor. I'm trying to give the jury the information, and the mean defense is trying to protect his client. You know what? If you want to give the jury the scene, then subpoena the guy like you subpoenaed the first guy. You freaking little lying weasel.
Hearsay.
I'm not introducing anyone's statements for the truth of the matter asserted. I'm introducing it for the state of mind of the defendant as he watches
If
the
it's
scene.
not for the truth of the matter asserted, it's irrelevant.
No, it goes to state of mind, Your Honor.
State of mind of
Of the defendant. When he sees...
someone else's. Would you do me a favor and step into the library for a minute?
I think he just kicked the jury out because he's going to tell them, quit playing fucking games. I hope he gets on his ass. Jury must be leaving. Everybody's standing.
Please don't talk about the case while you're out of the room.
He should have objected freaking 10 minutes ago.
And we've used them for a number of purposes. First off, the Court of Appeals very strongly condemns sidebars, and we've used them for a number of purposes in this case, which I think everyone would agree have not touched anything which is an essential part of the case, and mainly have been management issues. But the Court of Appeals rightly wants to have a full record made, which cannot be made when we're having a little sidebar.
Good. Sidebars were always where they cut little side deals and talked about stupid shit and played their freaking games in the jury, and nobody knew, and it was off the record. I'm glad the Court of Appeals said, stop the sidebar shit.
So, and when you state your objections, then I've stated you have to state the objection here, or else I'll have to excuse the jury, and I think that was, we're going to get into this a little more deeply now. So I think we did the right thing to do that, and we'll try to keep it so that they're not inconvenienced too much just being in the library here. No, let me just set the stage here. I've talked about inaccurate things out of the media, and one of the things that I've read over and over and over again is about how I messed up the State against Jensen case, which is now pending downstairs. Actually, I had it 100% correct in the first place. I ruled that the disputed matter was testimonial evidence that had to be confronted, and your office appealed. This is 20 years ago, and it was fine. It was a big issue. It was a big case, and the state Supreme Court reversed and said, no, we're going to adopt a new rule that is to be applied in this case about waiver and forfeiture. And so it came back, and I said right in the record, this is going to get reversed again because it was an unsound ruling, unanimous. I hate to say that about the Supreme Court, but it's true. And of course, that has proved positive. I tried the case according to the way the Supreme Court told me to try it. And that was 20 years ago. The man is still in prison. And the case has again been reversed because of the evidence that the Supreme Court told me to admit. I don't want to mess around with confrontation issues. I can't let you present evidence into this record, which is barred by the confrontation rule. And
when he's saying a confrontation rule, he's referring back to you can't introduce evidence to where the other side can't confront. So I can't say that, hey man, I had this witness that told me this, have the jury hear it, I get to say it, but yet the other side doesn't get to question the person that said it to find out validity. How do you know? Is it true? Everyone has a right to cross-examination and to confront the witnesses against them. And you can't do that if you can't confront the dude. And he's letting this guy speak on a video and nobody can confront him because the DA didn't want to subpoena him because he wanted to try to get it in the easy way like this.
Asking me to let this just run while this man is making descriptive materials to prove the state of mind of the accused, that doesn't make any sense to me at all.
First of all, Your Honor, nothing that's being said in this video can be construed as testimony.
There was historical information that he was saying in the part that we did here.
It is not for testimonial purposes. He is not presenting it in anticipation of litigation. He's not giving it to law enforcement. It's not a report for the purposes of reporting a crime or for any pending legal action whatsoever.
Okay, let's not even talk about it as confrontation. Let's talk about it as hearsay.
Then it goes to the defendant's state of mind, because the defendant is witnessing everything that's going on in this video. He is witnessing what's going on in the crowd. He's witnessing the response. He's witnessing all of these statements that are being made. And it goes to his state of mind. It's a present sense impression. And the defendant's state of mind, as we've all agreed multiple times in this case, is critical to the case.
Your Honor, start at the beginning for where I came in. The state argues that we've been doing this. One, Mr. Elijah, who was giving the editorial comments in the first video, he was here to be questioned. In this case, this individual who's in charge of the audio-video feed is not under the state subpoena. He could be. If they chose to do that, they could have him here, and he could testify to his opinions, and we could cross-examine those. That would be acceptable. What Mr. Binger is saying is, my client is there, so he knows all this. There's no proof that what that individual is seeing, filming, and commenting on, my client is looking at it, seeing, or part of it.
Great point. The DA can't say, hey, your client's state of mind because you heard all this. You can't say what my client heard and what he didn't hear.
That's why that person needs to be here to testify. I have no problem with this detective testifying as to people, places, and things from this video. We stipulated that. I did not stipulate to the editorial comments. I have no objection. Obviously, there's no basis for it when they want to play statements of my client that are on video. That's not hearsay. But this and his statements regarding militia, things like that, that is hearsay.
Absolutely.
We've got two complaints here, or two objections. One is the confrontation clause. This is not testimonial. It doesn't even fall anywhere near testimonial. Therefore, confrontation clause I don't believe is a valid objection. When it comes to hearsay, Your Honor, we had a pretrial dispute regarding things that Joseph Rosenbaum did all night long that were not witnessed by the defendant. The defense argued that those things should come into evidence because they show the context, they show his character, they show propensity for violence, they set the scene here. And I argue to Your Honor that if the defendant didn't personally witness it, it shouldn't come in. That argument failed. You allow them to come in. We've heard in the opening statement a lot of things about Joseph Rosenbaum that I know personally, and the evidence I think will demonstrate that the defendant never witnessed that night. But they're going to come in to attack the character of a deceased individual. And I understand the Jackson ruling. I've read that decision. I understand all of that.
If he's deceased, he doesn't have standing to challenge what's being said. Sorry.
The difference is, Your Honor, this is exactly what the defendant witnessed. He is right there. Now, counsel is asserting that the defendant isn't aware of what's going on at the scene. I don't know that. The defendant knows that. He has the right to testify. I'm going to...
Oh, that pissed the judge off. I don't blame him. See, if he gets that in front of the jury, they're going to do a mistrial. You cannot bring up that the defendant has to take the case in order to prove what he knew and didn't know. And now that freaking prosecution just said that totally insulted the freaking judge. I'm glad. I hope he says, you better not bring that shit up in front of the freaking jury. I'll have your ass in contempt and I'll mistrial.
Wait a minute. You're right. He has the right to testify. He has no obligation to testify.
Absolutely not. But if he's going to get...
And if you're going to,
he is present. He's within a few feet of all this stuff going on. So it is a perfectly reasonable understanding that he is witnessing this and that this is forming his state of mind. He is seeing confrontations. We are showing the jury those confrontations. These are occurring right in front of his face. So this is him right there. I'm not showing stuff that was 10 blocks away. I'm showing what was right in front of him as he's witnessing. We've already seen him in this video. Now, if the defense wants to argue he didn't witness it, if they've got evidence to suggest that, they can argue that and the jury can make a decision. This is a factual dispute. The hearsay objection, again, these are not being, no statement that I'm...
Now, I want you all to remember this because it sounds like he's making all these great points. None of these points matter if he just subpoenas the guy that made the tape. He gets everything he wants if he has the guy come in who made the tape. But he doesn't want that. He wants to be able to do all the if, and, buts, and coconuts and slide it in sideways, and then that way the jury might get confused and say, oh yeah, he did know. He should have known.
That I'm showing this video is being offered to prove the fact of the statement. But hearsay does not necessarily have to be admitted for the truth of the matter asserted to be relevant. It can be admitted for other purposes, such as present sense impression, state of mind. These are excited utterances that are going on in the heat of a conflict in a scene like that. So there are plenty of hearsay objections.
So many things you're touching on.
Okay, I'm at 32 minutes. We're gonna pick this up on the next one. This is getting good too.